Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about residential school claims. Cases that should have gone to the Supreme Court of Canada, but didn't. P. James Walbridge was a lawyer representing an individual in a residential school survivor claim process. Unfortunately, he was unsuccessful in securing a compensation claim for that individual. The individual appealed through the internal mechanism provided, was successful in his appeal, but with a different lawyer. Ultimately, the individual who was subject to abuse and torture at the residential schools sued Mr. Wallbridge, claiming that had he represented him properly, he would have received a different outcome. This was the case that was ultimately sought leave from the Supreme Court of Canada. The issue was whether or not Mr. Walbridge, in his capacity as a lawyer, could be sued based on the outcome of the case. There was no evidence that he had done anything negligent in his representation, no evidence that he had done anything wrong as far as a lawyer. He was just unsuccessful in the outcome. And the reason the case was unsuccessful was that the original arbitrator had found that the claimant himself was not believable based on his description of what had happened to him in residential school. So it also wasn't an issue of any legal error or omission made by Mr. Walbridge. It was a credibility determination based on the witness's testimony in the hearing process. And this case raises important issues because as lawyers, of course, people always want to know whether or not you can be sued and how far you have to go to prepare your client for testimony. A client that's overly prepared to testify may come off as wooden or rigid or rehearsed and be less believed. A client that's insufficiently prepared may not know how to respond to tricky questions and might find themselves inadvertently in a trap by opposing counsel. There is an important line in preparing a client for testimony. But where is that line when it comes to ineffective assistance of counsel? And when does crossing that line or not crossing that line expose a lawyer to a claim against them in negligence? The claim was ultimately dismissed on the basis that it was frivolous or vexatious, but really the claim raises important issues about the role that lawyers have to play in litigation and tribunal proceedings in preparing their clients to go to the tribunal and what lawyers need to do. What is effective assistance of counsel in advising a client about how to testify and preparing them for their testimony? This is often a matter of dispute and debate amongst lawyers who have different strategies for how to prepare their clients. This case would have given lawyers and the legal community and people accessing legal services better certainty about what to expect when it comes to preparing a client or being a client who's being prepared for testimony. And this was an opportunity that the Supreme Court of Canada missed to deal with something that they should have dealt with in the circumstances of this case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.